and then I just sent in questions, so I then followed up with like questions. Everybody ready? All right. Okay, good afternoon. Thank you so much for your time and for coming to this panel discussion. I'm Trina Jones. I'm the director of the Center on Law, Race, and Policy here at Duke Law. And I want to tell you just a little bit about the center, and then we'll turn it over to the panelists. So the Center on Law, Race, and Policy, CLRP, is committed to augmenting understanding of the interplay between race and law. And we do that through educational programming like this, and also through scholarship and through community engagement. And our ultimate goal is to produce more racial equity, period. And we do that by looking at historical structures that have led to racial stratification, as well as examining contemporary developments like generative AI, which also may produce some benefits, but also more racial inequities. So I'm delighted that we're having this conversation today. We'd like to thank our sponsors at the very beginning, BALSA, LAWSA, and the Social Science Research Institute. To introduce today's amazingly talented panel is the new executive director of the Center on Law, Race, and Policy, Giovanni Martinez.
Good afternoon, everyone, and again, thank you for being with us today, whether in person or via live stream. With us this afternoon, we have April Dawson, Associate Dean of Technology and Innovation and Professor of Law at North Carolina Central University School of Law, author of a recently published book, Artificial Intelligence and Academic Integrity. Dean Dawson is a frequent presenter on legal pedagogy and the use of technology in legal education. Professor Dawson teaches and has taught a wide range of courses, including constitutional law, Supreme Court seminar, torch, artificial intelligence, intelligence foundations and the law, and legal technology, equity, and leadership. And she's also one of our faculty affiliates for our Center on Law, Race, and Policy. Jessica Eaglin, a Duke Law 2008 alum and professor of law at Cornell Law School, seated in the center of, three to my right, to my left. Professor Eaglin's research examines the expansions of technical legal practices in criminal administration as response to the economic and social pressures of mass incarceration. Professor Eaglin is a leading expert on algorithm in criminal sentencing and previously served as counsel at the Brennan Center for Justice at the NYU School of Law Justice Program. She, in that effort, was assisting in a national campaign aimed at addressing mass incarceration in the United States. Seated second from my left, that we have Sonia Gibson Rankin, professor of law at the University of New Mexico School of Law. Professor Gibson Rankin is a member of the Interdisciplinary Working Group on Algorithmic Justice, a collaboration of computer scientists, legal scholars, and social scientists from New Mexico who provide insight to attorneys and government officials on the issues related to artificial intelligence. A fellow at the American Bar Foundation, Professor Gibson Rankin regularly presents on topics such as AI, kinship care, criminal justice reform, implicit bias, inclusive leadership, and Black community empowerment. And we have Margaret Hugh, seated fourth to my left, a Duke Law 2000 alum and the Taylor Reevely Research Professor and Professor of Law at the William and Mary Law School. Publishing several works on data surveillance and cyber surveillance, Professor Hugh is a research affiliate with the Institute for Computational and Data Sciences at Penn State University and previously served as Special Policy Counsel in the Office of Special Counsel for Immigration-Related Discrimination in DOJ's Civil Rights Division. Professor Hughes' research interests include the intersection of immigration policy, national security, cyber surveillance, and civil rights. Ladies and gentlemen, please give our panelists a warm welcome.
Thank you. Trina, Giovanni, thank you so much for inviting us to participate in this incredibly important discussion. The work that you're doing with the center is so imperative, and we're delighted to be able to kind of kick off the new launch, if you will, of the center. All right, I actually am going to start off with a poll. So we're going to get some audience engagement. So if you have your phone, go ahead and take it out. And you can click on this QR code. Oops, actually I'm going to hide the results for now. All right, so first question. Do you agree or disagree that AI has the potential to benefit marginalized groups? So strongly agree, agree, neutral, disagree, or strongly disagree? And right now we have about 41 respondents. Let's give it just a few more seconds. All right. All right, so over half agree, right, that AI has the potential to benefit marginalized groups. We've got about 20% neutral, 16% disagree, 11% strongly agree. All right, next question. All right, next question. Are you concerned about the possible negative impacts of AI on marginalized groups? Very concerned, concerned, neutral, not concerned at all. Are you concerned about the possible negative impacts of AI on marginalized groups? All right, we're at about 40. All right, so 52%, very concerned. So more than 50% optimistic, if you will, about positive impacts that AI can have on marginalized communities. But we're seeing about the same percentage, not necessarily the same people, but the same percentage that are very concerned about the negative impacts. All right, last question. Are you more optimistic or pessimistic about the impact AI will have on marginalized groups? All right. So almost 75% are either pessimistic or very pessimistic about the impact that AI will have on marginalized groups. I think that's really, really telling, and it underscores why it is that we need to have these discussions, right? As the technology is evolving and emerging, we need to be talking about these issues. And so this is actually a great segue to start hearing from our panelists about their thoughts on the impact that AI is having. And so our first panelist, let me go ahead and close this out, is Professor Gibson Rankin. And you, Professor Gibson Rankin, undergraduate degree, computer science, we have that in common. Deep thinker when it comes to technology, when it comes to race. So you're going to help us understand what's going on inside of the black box, inside of the technology. And then I'll ask you some questions about the impact that AI is having on these communities.
Absolutely excited. If you could just hit share presentation and I'll. So good afternoon, good afternoon. I thought I was in the South. I said good afternoon. There we go. All right, listen, I'm half Southern, I'm half Panamanian, but I'm 100% Jersey girl. That means I talk fast, and I'm gonna try and use my 5 minutes wisely. So I'm just gonna give you a little sense of this inside the black box of generative AI. And I want you to keep this theme and this point inside, right? Where there is no law, the technology will develop without any boundaries. I believe this, I think about this in my research, my writing, and my work in this area. And so, let me save you 5 minutes, too long, didn't read. There are ways to mitigate bias in AI. But along the way, I'll just give you a little bit of a sense about what are different types of bias in AI, how we were attempting to mitigate it through tech and law spaces, and fairness isn't fair. I want us to think about that concept as a mathematical construct. Fairness isn't fair. And later on, we'll talk about some general ways that we're looking to mitigate bias in AI. And it was shared on part of the UNM Santa Fe Institute Interdisciplinary Working Group on Algorithmic Justice. The name is terrible because we have no marketing people. But we are intentionally trying to be a resource for our state, for all of the things that are in place. And along with Dr. Melanie Moses and Dr. Kathy Powers, we are co-founders of the UNM Algorithmic Justice Project, where we're attempting to educate on these areas. So there are tons of risks of AI. Tons of risk. We're looking at risks of job displacement, of bias, of deep fakes and persuasive AI, of weaponization. There are so many, but we have been called to only focus on one type of risk that we are looking at, which is the risk of bias as it relates to more vulnerable populations. With that in mind, we're looking at this lack of fairness in the output generated by algorithms. And these biases can include age discrimination, gender bias, racial bias, gender expression, and we watch all of these kind of things at play. So let me tell you a little bit about the black box. The black box is a term that is used in the tech community. It is this understanding that there is some type of input, something happens, and there's an output. And I know I did it, I just don't know how I did it. I mean, honestly, if you were to call developers onto the stand and put them under cross-examination and say, what is the box doing? They will answer honestly and earnestly under oath, I don't know. That's a heavy thing for us to think about, right? Well, you already know in cross-examining, you don't call up a witness if you don't know what their answer is going to be. And they don't even know what the answer is because we actually earnestly do not know. And what we understand is that there are things called interpretable kind of ways that AI can work. And, you know, there are methods, old school coding, the coding that Professor Dawson and I came through way back when under old school Pascal, and oh, you guys don't even know about those days. I mean, there's ways that we could, it was if then else statements. We could track down what went wrong because we had access to transparency and we could visualize what was happening and we could just tell the code, show me some features. But right now, the way it works is that under machine learning and deep learning models, we can't actually do that. The tech doesn't work that way. And there are lots of different kinds of biases that we're looking into. We're looking into societal biases that then play itself out in input. We're looking at algorithmic bias, whether it's cognitive bias of the individuals who are taking the data and what they're doing to it. We're looking at incomplete data where we don't even have a full accounting of what's being put inside. And then the aggregation bias, that by the time we come to this at the end, it will be very complex to look at. So from here, we have computational biases, human biases, systemic biases that are at the very base of what we're looking at. And we've got two use cases I wanted to just present. One, which is Loomis versus Wisconsin, and this was pretty famous, in which Mr. Loomis was sentenced and the judge got access to a algorithmic equation to look at, which gave a recommendation for a sentencing. Mr. Loomis asked the court, why did you sentence me as you did? And attempted to get the question raised, what was in the decision-making of the tech? The Supreme Court of Wisconsin came back and said that judges don't have to not use it, but they should be taught a series of warnings of the really deep concerns about the technology. A second instance that just happened, and we were studying this out of Wisconsin, is Bosserman versus Unemployment Insurance Agency. And I just wrote about this in the New York Law Review online, in which we were kind of studying this algorithm. This isn't even a fancy AI. This is just algorithmic thinking, an if-then-else kind of structure that was wrong 93% of the time and unlawfully took 32,000 individuals, garnished their taxes and their wages. What do you do when an algorithm is that wrong? For half a decade, it took people a chance to try and get recourse. Fairness isn't fair. And I raise this with you as attorneys because in the world of computer science, in the world of mathematics, there is no mathematical way to prove or create fairness. There's no proof for it. Anyone remember proofs back in geometry days, right? You can't do it. It actually can't work. There's no way to write an algorithm that is fair to an individual and fair to the mass population. So what do you do when math can't do it, but we know how humans act? The problem is not the Terminator, right? It's coming, not today. But it's not here. The problem are the old school things that we've been watching, the biases of colorism, the biases of gender, the biases that have already just been instituted. And what we're looking at is what I call a Pandora's box of Pandora's boxes. We have a series of unknowns, but the next set of unknowns is what we're very uncertain of. And so we're now going to, the AI made this. I just think she's so cute. I don't mind. I try to do my hair like her on every now and then, but I'm excited for this chance to kind of share some other ideas with you. Thank you.
Thank you, Professor Gibson. All right, so Professor Egeland, so Professor Gibson-Rankin gave us an insight into the black box. She provided a couple of examples. So you do your research in the criminal justice or criminal legal system context. Can you share some ways that AI is having an impact on marginalized communities within the criminal law context?
Sure. So, just a point of clarification, when you talk about sort of AI and marginalized groups, speaking in the criminal law context, we're really talking about sort of the introduction or the potential introduction of machine learning algorithms. So right now, there's already sort of quantification of a series of determinations around sentencing, which is the context that I particularly focus on, right? We've got things like guidelines, we've got things like sort of structured efforts that are based on some data to guide decision making. But with the onslaught or the advance of artificial intelligence, we're looking at the potential for machine learning tools where you basically ask the tool a question, and in the context of sentencing, that question would be, how likely is this person to engage in criminal behavior that we define as recidivism? That can mean a number of different things. And once you ask that question, you get, high likelihood. medium likelihood, low likelihood, right? And the question within that is like, what is the tool actually telling you, right? What is the information that it's based on? And as we move towards machine learning, we don't actually know necessarily what information it's based on, but it's answering this particular question. All right, so as I said, in the context that I study it, mostly in the post-conviction sentencing context, we've got algorithms that assess whether a defendant is likely to engage in recidivism in the future. And that determination is increasingly important in the era of mass incarceration, because one of the ways that many states and the federal government have responded to the economic and social pressures of the United States being one of the lead incarcerators in the world is by trying to divert certain people. So instead of using algorithms to predict who should get the longest sentences, sort of the most popular way to talk about algorithms right now is to think about the ways that we can use them to identify people that are best sort of qualified to be diverted from prison into treatment programs, into other types of sort of community supervision. All right, so this is important context to understand the sort of three ways that my own research has thought about the impacts, the potential impacts of AI and algorithms on marginalized groups in the criminal law context. The first level connects with what Professor Gibson-Rankin just identified for us, right, which is that the practices themselves can be implemented in a way that is going to distribute sort of punishment and surveillance to be even more concentrated in marginalized groups than they already are. And this goes to sort of the technical background of the algorithm itself. So we know that algorithms rely on pre-existing data. In the criminal law context, they often rely on arrest data. They rely on criminal convictions. They rely on things like gender. They rely on things like age of first arrests, things that have some connection to the administration of criminal law, but we know in this moment, right, that these are also deeply shaped by racial assumptions, socioeconomic background, right? Who gets sort of targeted by the police is shaped by our human practices, and those are racialized. All right. So the concern then is that the algorithm is going to just sort of regurgitate what we already do in society and just entrench and distribute sort of punishment along these racial lines. So more people of color might be identified as high risk, leading to longer terms of incarceration, longer terms of community supervision, and or placement in prisons and jails as opposed to in the community, and that would be distributed on the basis of race. That's one level. All right, so we move down from the practices to the ways that algorithms and technology can actually shape our institutions. So one of the other points that I have written about in my scholarship is the way that algorithms and technology have been used to depoliticize certain concepts, for example, rehabilitation, and to justify expanding criminal law responses to social problems as opposed to sort of structural concerns about how we invest our resources across different institutions, right? So saying we can do rehabilitation better if rehabilitation really just means predicting who is likely to engage in recidivism in the future and then putting them on criminal surveillance. If we think that's what rehabilitation is, right, and the expansion of algorithms has sort of legitimated that sort of framing, that also has a deep, significant impact on marginalized communities, because marginalization, of course, is the product of social decisions, right? The ways in which we have structured society to respond to social problems. And if we expand algorithms, we also, in the criminal law context, we also legitimate the expansion of criminal law as a response to social problems. All right, so that's another level. Then we have this sort of third level, which my most recent scholarship is thinking about, which is thinking about the ways in which our criminal legal practices also teach us, right, what we know about the world. So in this context, I've been thinking a lot about sort of what is race, right? Race is you hear the sort of pithy comment all the time, like race is a social construct. People mean lots of different things when they say race is a social construct. When I say it, I mean that race is a series of signifiers, right? Things like cultural markers, things like racial markers or physical sort of markers, things like the color of your skin, the type of hair you have, all of these things, right? That we attach to particular social meanings. Okay. One of those social meanings that has been sort of dominant when we talk about race in the United States is the idea that race is fixed. It's not. So my skin color today says I'm black, but my skin color maybe back, pre-chattel slavery, in chattel slavery, might say that I was Quintaroo or whatever, Onctaroo, and whatever they say, right? There's these different categories, and there's plenty of debate about sort of how we define who fits into what category. That changes over time. Mm-hmm. What's important and has been reproduced in law in different ways over time is the idea that race is fixed. The idea that race is a thing that already exists in the world instead of a thing that we create. Now, we can see in the context of algorithms expanding in criminal law, the reproduction of this idea that race is fixed. And it is happening, a good example of sort of where it's happening is in the effort to address how to fix the problem that algorithms are likely to impact marginalized communities most significantly. And we have in legal debate sort of two responses, right? One way is to try and keep all the responses say we should keep the algorithms, right? But they say, let's keep the algorithms, but let's scrub them of some of the most racially significant predictive factors. Something that we can't necessarily do when we move to machine learning, but something that we are sort of debating about, should we be able to do it now, right? So removing things like criminal records as a predictor of recidivism risk, removing things like age of first arrest, if we think that that is, that it correlates with race. Okay. Underlying that sort of recommendation is the idea in criminal law that race is a factor we should not punish somebody for, right? That it's so fixed in society, you can't change it, that in order to sort of punish someone fairly, we shouldn't rely on those kinds of factors. Underlying that assumption is the idea that race is fixed. On the other hand, we also have a burgeoning legal scholarship that is arguing that actually, right, even if we cut out all of these risk factors, if we cut out these predictive factors like criminal records or age of first arrest, et cetera, we'd still see algorithms that continue to disproportionately target marginalized communities. So instead of trying to scrub the algorithm of these racial identifiers, we should be predicting risk in light of those racial identifiers. In other words, there's lots of conversation about how do we start to consider race in the design of our algorithms. And the critique is that the problem is law won't let us do it. All right, but underlying this argument is in fact the same social meaning, right? The idea that race is such a predominant social fact. It already exists in the world. We should just try and take it into consideration, and law's not letting us do it. That is also saying that race is fixed. So what we see at the intersection of both of these sort of struggles about what we should do about this legal practice is the production of a social meaning that race is fixed in society that has long been used, and since I don't have enough time, can't really talk about how it is continuing to be used, right? That race is used as not just a social construct, but a political construct, one that normalizes and leads us to sort of desensitizing ourselves to the way that racial hierarchy operates and is structured in society. All this is happening in the context of criminal law reforms and algorithms, not always something that's at the forefront, but each of these layers is always at play.
Thank you, Professor Eglin. So, Professor Hu, we've had discussions about fairness, about data, about concepts that underline democracy. how do we maintain and reinforce democracy in the age of AI?
Thank you so much for that question. When I think about reinforcing democracy and advancing justice and equality in the age of AI, I think about three things. I think about law, power, and philosophy. So I think the critical question that we're being faced right now is, will AI govern the law or will law govern AI? In our history, we've always seen anything that's shameful and disgraceful in our history justified under the law. And when we come to abuses in AI, we might see the same thing without being very vigilant. And when we think about power, I think we can't talk about AI without talking about power. I don't think we can talk about race without talking about power. And in our Constitution, in our Bill of Rights, we had our founders try to enshrine rights and constrain power. And so now I think the question that we're forced to grapple with is, how do we continue to maintain those ambitions in light of the new challenges and threats that we see with AI? And finally, with philosophy, I see AI more of a philosophy than a technology. And I think that unless we grapple with AI in its capacities and its ambitions on that level, then we will have a very hard time finding regulatory structures for it. So when we think about how are we trying to exercise some type of governance right now over AI, I often go back to the White House Office of Science and Technology Policy's AI Bill of Rights. The blueprint was issued a year ago, and it supported 5 principles for trying to create some type of AI governance structure. And those 5 principles were: 1, fair and safe systems; 2, privacy; 3, anti-discrimination principles; 4, notice and transparency; and 5, human alternatives and human in the loop structures for AI. And I think what that forces us to think about are whether or not rights are changing, whether we need a new conceptualization of rights, or are we going to be able to interpret and broaden our current jurisprudence of rights and equality so that we can capture some of these new harms. We also have in the EU the proposed AI Act, which uses a risk-based classification model for AI governance, and it classifies certain harms as being unacceptably high. And so things that AI systems that target individuals on the basis of classification and race, for example, are prohibited. Cognitive types of subliminal messages and other types of psychological influences of AI are also considered unacceptably high risk. Biometric systems, many of them are considered unacceptably high risk. And so that is also another structure. We've seen various states and we've seen Congress propose, have not passed, but things like the Algorithmic Accountability Act. And so we see multiple types of movements in the law to try to grapple with and recognize that these types of harms are in need of some type of new legal oversight and new regulatory structure. When we think about equality, however, in AI, I think that this is incredibly difficult because we have a structure, as we've heard, that is very black box, and our rule of law often assumes that there's a certain transparency and understandability in order for us to try to create causes of action and to be able to litigate and reveal and create remedial structures. And so I think we're really going to struggle with how do we address harms that are more about surveillance, about predictive policing, about risk assessments that are having a disparate impact, secret credit, social credit scoring systems. I think all of these are challenges that we're really going to have to try to understand and trying to address. And it's not just the technology that is a black box. Oftentimes, the other black box part of it is the fact that we often do not understand the interpretation of the user. So it is a twin black box problem that we see. Also, I think that part of the challenge with reinforcing democracy is that we are in the middle of information warfare, where we're seeing the weaponization of AI in ways that are extremely difficult to tackle, and that part of this goes to the question of philosophy and AI, is that AI is a knowledge structure. And so it deeply impacts how we see epistemology and ontology. And so what is knowledge itself, I think, is changing in light of these technological capacities. And so part of what is very difficult, especially with the rule of law, is that we often take things literally. AI often functions in ways that are symbolic, metaphoric, and correlative. And so the knowledge that it generates often cannot be taken on face value. I think that we're seeing that with all the hallucinations with ChatGPT, that it requires an extra layer of investigation and interrogation that I'm not sure that we have quite found a way under our current legal structure to address. So those are some of the types of anchoring concepts and questions that I have when I think about AI's disparate impact.
Professor Wu. So we have a little bit of time before we get to your questions. So as I reflect back on when I was in law school, and I won't tell you how many years, but I think it's safe to say that when we were all in law school, we of course weren't having these discussions about technology. Of course, technology existed, but not the way it does today. And one thing that we know is technology impacts every aspect of society, which means it impacts every aspect of the law. And it's vitally important that law students think about whatever area it is that they want to kind of do the deep dive or focus on, that they consider the technology implications of that. So I want to go to that last poll question, and I want to ask each of you to answer it and to kind of share why that's your answer. So the question was, are you more optimistic or pessimistic about the impact AI will have on marginalized groups? Right. Professor Gibson Rankin, let's start with you.
I was hoping that my most negative answer would be last to share, but I am not. I have no indication of studying 400 years of Black presence in this country to show that they will take care of Black people. And every time they've gotten access to our data, it has been used to harm. Think about that, right? Every time we have worked to codify the law and change it and tweak it and do these small things, it has led to no significant change. I am very mindful that when Professor Dawson and I came through a computer science, that I was the one in a room many, many times. And my children, now in tech and STEM, are still the one in the room many, many times as laws have changed. So I am not feeling optimistic at all. And this concept of AI as a philosophy, that is powerful on a whole nother level, because you could put any other system in place, but because of these embedded things in our societal norms, there's nothing to show that there has been a significant work to change some of these outcomes. There is one thing that is being very different. And it is a rise of persons of color and people of cultural backgrounds in tech and STEM who are using their spaces to attempt to raise things that I don't think we had that at this level in the past. I wonder if that can make a difference, but I'm not optimistic.
Thank you. Professor Eaglin.
So thank you. I really enjoyed that poll question, and actually I appreciate this question too. I had written down on my notes, that's not the right question. So but I appreciate it because I think that it's like this paradigm of like, we either have to be for it or we have to be against it. And that's a disempowering question when you think about marginalized groups, Black people in the United States, right? That, you know, if we only can choose one side, then we have stifled our creativity, and we stifle our creativity in law to think about ways in which we can disrupt the reproduction and creation of hierarchies. So to me, it's not about, you know, I guess if I had to pick a side, I'd say I'm sort of optimistic, but not really about the algorithms. Like, that's a problem, right? But I'm really optimistic in the ways in which we can be creative and confronting this moment of transformation, and the ways in which technology is expanding and shaping our society, to think about and imagine differently, imagine society being differently structured and functioning differently. And I see opportunities for that everywhere that technology touches the law.
Thank you. Professor Hu.
Yeah, I'd like to have that optimism, but I'm having a hard time being that optimistic. I think especially given that the paradox has always been that, you know, for example, Plessy v. Ferguson was a theory of equality, that we've found ways in a very, I think, Darwinian way to try to evolve and adapt technologies in the law in order to meet those pre-existing commitments to racism. And I fear that for AI, racism will be the default. But I think simultaneously and ironically, technology and AI will be presented as the solution. So I think over and over again, we're going to see, and I think this will be a very hard push in big tech, is that AI will be the solution to everything, including racism, and yet at the same time embedding more and more racism.
So I use this because I feel that it stands out to me is that people are treating AI like magic pixie fairy dust. That if you just sprinkle some AI, it'll taste so much better and it'll solve everything. I saw a commercial for a washing machine that said, it's got AI. And I'm like, I think we've gone too far because there's this, I think you're absolutely right. We're not quite sure of where it fits. And so right now it's supposed to fit everywhere and solve everything.
Yes. So anytime you hear me talking about algorithms in criminal law, it's negative, right? But I don't think that the algorithm is the problem, right? Like what you just described, it's like the problem is racism, right? The problem is all the other isms that we in society keep buying into, right? And so there's always opportunities in law to break that up, to think about things otherwise. Now, I also will recognize, right, that that's a lot easier to say from sort of the philosophical perspective, but I really like this point you made as well, which is if we begin to think about AI not just as this thing, not just as technology, but as a way of making us think in a certain way and disrupting the way of thinking, I think that there's a lot of power there.
And last question before we get to your questions, which kind of piggybacks on that, which is, because I love technology, I love, studying it, writing it, coding, but I am feeling very concerned about whether it's going to be used to continue marginalize, groups. And what advice or suggestions would you give law students about how to make sure we are able to prevent the greater harms? I'm gonna let you all go ahead and decide.
We'll let Margaret go first.
Well, I think we, in the Legal Academy, can start with the law, and we can think about what tools we have currently for civil rights, and you saw that with the commitment joint letter that was issued by the EEOC, FTC, CFPB, and the Justice Department Civil Rights Division saying that we will use every tool that we have under civil rights laws and consumer rights laws to enforce against discrimination. And so I think for law students to think very carefully about what they have right now as they study, as they go into the legal profession, as they see themselves crafting theories moving forward, what can we do right now? And then also think to the future, what types of laws do we need, or what type of jurisprudential developments do we need to be able to continue to try to preserve equality, justice, autonomy, dignity.
So I agree with that. I also would say, so a little background on myself is that I got my JD here, but I also got my master's in literature. And, I think that there's this tendency when you confront technology that you have to talk in the way technology talks, like we should all suddenly, be computer scientists. No offense to my computer science folks, but I think that what we need is to draw on our own tools, the things that we know that include things about, society, not really the technical, yes, you have to understand how algorithm works. You have to understand, how and why it produces some of the results that it does. But then we have to look outside of the technology of it, right? Look to things like history, look to things like, discourse, other things, not to say that it's a one or the other, but we need to bring all the tools to the table. And I think law actually is the platform, the forum in which we can bring all those different kinds of disciplinary tools into a space when confronting technology.
Those are excellent insights. I'm pondering them. I'm not sure if I have anything to add on it, but I've been thinking a lot about what Professor Hu said as it relates to the tools we have under the law. And anyone love torts? Any torts fans? Yes, those online, you can't see all the hands. There's so many hands. But think about it, right? This is where it's going to happen. It's going to happen in tort law, right? That's the place where we're going to see the biggest changes. These things are happening in corporations. Do I have more torts hands? I'm just waiting till the momentum builds up. But right now, the causes of action we use, I find to be insufficient. They're not going to fit into strict liability. It's not going to fit into intentional torts. It's not going to fit in negligence. It's not going to fit in customs with under breach, because the corporations have worked so diligently not to make standards that we have no standards to say that they've deviated from in AI. So what I believe law students should be getting excited about when studying torts is looking at how we're going to think about the cause of action we have and where this ethereal thing that doesn't fit anywhere to our historic American and world senses of what is can actually fit or doesn't fit. Or is it time we do something very, very radically new? That's what I need you all to start working on.
Excellent. And I'll just take a moderator's privilege and add to that. One of the things that I emphasize to my students over and over again is that when we think about policies and laws and regulations, those who are tasked with developing and creating, many of them do not understand the technology that they are being tasked with regulating. You all, even though you all are consumers of technology, you got to rise above that. Every one of you should be reading those policy statements or the privacy, right? We all click through it, right? We all do, right? But you all have a higher obligation to understand how your rights are being affected as consumers. If you start engaging in that way, that'll help you to elevate your thinking about these complex problems. To the extent I'm optimistic because of you all, right? You all are our future legislators, judges, lawyers, advocates, and you need to embrace that, right? And start, kind of interacting with the technology and engaging in a more sophisticated, complicated level. All right, so it is time for me to be quiet, and we're going to have questions from you. Yes.
So I'm actually a machine learning engineer. I'm from undergrad. I just came over because I love this conversation. So I was really fascinated by two things. One might be too technical, which is you mentioned that it was hard to get rid of the pieces of data that correlated with race, and you were thinking maybe we keep race back in there and build algorithms that act in spite of that. That's going to be a week of research for me for the next week. So let me ask a more maybe policy question. It's something Professor Wilson, you mentioned, which is that you found some math proof that said that algorithms cannot both protect individual rights and group rights or something like that at the same time.
Yeah.
And I'm curious what all of you think. Is that something that we should have a clear stance in the law of what should be prioritized, or is there room for both, or how do we navigate that?
If I could play with some of the what's happening with risk assessment instruments when we think about proxies for race, what we can't wait for you to do once you come to law school and you don't want that undergrad thing, is to start to wrestle with some of the things that we know in terms of constitutional protections for equal protection and due process. That even when we try to do things related to race, if it can lead to any kind of discrimination and that can impact governmental things, right, do we have coders in the room thinking, oh my goodness, if I put in this race leading question or this race proxy, am I violating equal protection? So that when a judge someday looks at at my decision from my algorithm and says, oh, I agree with it. You've just helped that judge violate someone's equal protection or due process. I can guarantee you there's maybe 3 machine learning experts out there who are wondering about that when they're coding and thinking about this. Am I coding in equal protection violations? That to me is a grave concern. Now, as for policy considerations and this idea of fairness and unfair, this is why you got to come to law school, number one. But number 2 is we don't have an answer, right? That's what we give to our juries. That's what we give and what we wrestle with and go through time as we look at the law and its purpose. And we are constantly reaffirming what is fair generation after generation. I know there's not one tech person in the world that wants to hear. I've never heard anyone say send it to the lawyers. I've not heard that used, but that's something I think makes it very hard. Colleagues, what are your thoughts on that?
Okay, all right, thank you. Thank you. Back here? Yes.
So I'm not a student, but was a student here many years ago. But I've actually been building businesses using AI for nearly 20 years. And we're building a new business. And the idea behind the business, at least in part, is that we can democratize contracting. And by doing that, we're giving AI to both sides, and we're also giving both sides market data. Are we going to perpetuate the things that we're trying to prevent?
Yes. Colleagues? I would say yes. The reason I would say yes is because there has been this answer, right, that if the AI is going to discriminate, then just build the bigger mousetrap, right? Build a bigger thing to battle it. So now we've got the battle of the AIs, which is, just to be clear, I don't even think we got to say this as clearly as we should. Generative AI, what we kind of see in our modern day chatbots, don't actually know anything and they don't understand. This is a big debate among deep thinkers on this, but they don't understand. It is simply predicting the next most likely word based off of the world we've all lived in. So if I say roses are red, violets are? Blue. Thank you. Green means go, red means? Stop. Cherries are red, grapes are? It depends. I heard my lawyer out there. That's right. What is the next most predictable word? That's what the AI is doing. It's not determining this is the best grape, or it's this is the most in season, or this base is a good North Carolina grape, or this is a good Mexican grape, or this is a good thing. It doesn't know. And so now if you have this battle of who knows what happening, what happens when the humans are getting a surface picture of all of the intricacies that go in that what you and I do as humans. When we think about contracts, we've seen this happen, and no disrespect to my colleagues who work so very diligently on access to justice, we already know that when people write their own wills, they end up leaving everything to themselves because they write their names in the wrong boxes, because they don't actually understand the depth of what is in a contract. So what happens when the AI is just guessing at a predictable next word, and then you and I come to a document and we're like, I think it looks about like what a contract should do or say. I worry. Those are my thoughts.
So I'm having an out-of-body experience because I'm usually the most negative person on a panel. But in this moment, I just want to say that I can't say much specifically to what your company is doing, but I do think that there's a lot of promise in the impulse towards democratization and algorithms. Now, there's a big question, one that is not answered by the algorithm itself, which is like, what do we mean when we say democratizing, right? Do we mean by democratizing bringing in sort of select voices that we already identify as marginalized? Do we mean by democratizing asking and giving the power for people who are not sort of already empowered to think about responding to social issues differently? So in the criminal law context, I think of a friend of mine, colleague, Ngozi Okedegbe at BU, but she's written a lot about, how could we imagine, empowering people, the most marginalized groups that are most targeted by algorithms, to design algorithms themselves, right? Like, do we say, you choose what factors we should include or not. But most important from that contribution is to say, you get to ask the question whether you want an algorithm as a response to mass incarceration, or perhaps you would rather us invest this money some other way. That's real power, right? Not saying I have confined you to, the questions I want you to ask, but also allowing you to imagine otherwise, right, in this context and through law. So, I think that, there's promise and peril in the framing of democratization and algorithms. I've written a little bit about it too. But I think if we can bring, as I said already, these other tools, right, that isn't just like, how can we make the technology be the tool of democratization, but how can we think about what democracy means and imagine in the context of technology, there's promise there.
Right here.
Thank you for your inputs. I'm from the country of Georgia, and I work at the Ombuds Institution at the Quality Department, but we have not had any single cases or any issues related to artificial intelligence. So my question would be, in context of like my country, how can we start? Where can we start to identify where AI is being used, who is using? Because we've been trying to do that, but we haven't been able to identify where can we engage in that process. So could you share any possible inputs so that which can guide us?
Yeah, I mean, you could start with disclosure, and if it's from a government point of view, the United States and the White House with their anticipated executive order that in the news anyway, they said that might be released on Monday. But there's questions about procurement, for example. So before you have any contractors signed, are they using AI? How are they using AI? And having just more transparency.
Thank you. Other questions? Yes.
So I also agree with your guys' opinion that overall, society impact is kind of pessimistic. But in terms of AI overall, I see a pretty optimistic viewpoint comes from the impact for the individuals of marginalized groups, in that AI can provide a resource for them that otherwise they don't have the financial means or relationships to access, or at least direct them to the right resources. And I was curious if you guys have an optimistic or pessimistic view specifically on the individual level as well.
I think this goes back to the question about democratization in AI and whether or not there's a very robust, for example, conversation about access to justice in AI and especially in access to legal knowledge and services, and whether or not there can be. But also, I think that it's important to think about all the ways in which AI can be useful. This is going to, I think, a more optimistic view and how we just need to provide better oversight and regulatory structures to make sure that the positive uses that we see can flourish and that innovation can continue in ways that positively contribute, including enhancing opportunities and civil rights. There are ways, but to try to minimize the greatest harms.
So a concrete example that your question makes me think of is in the criminal law context. Like oftentimes algorithms are used to, they're framed as risk and needs assessments, and they identify what likely sort of services an individual might need in order to, re-enter society without engaging in recidivism again in the future. And I think that there's this deeply political question that the sort of conversation about, of course this is good, right? If somebody needs some services, we want them to be connected with those services. But if we only offer those services in the criminal law context, they are often to always connected to punitive surveillance and the potential of either staying in the criminal justice system, as a community supervision, model, or, ultimately, reincarceration or incarceration for the first time. So, I think that there's this political question of, okay, well, it's great that we want to identify services that people need, but why do we have to offer those services through the criminal justice system? If that's how we're implementing the algorithm, if that's the space where we're adopting it, it sort of takes us away from that bigger question that isn't just about, the benefits for that one individual, but about the way we choose to structure society.
I've been thinking a bit, and remember, I'm a computer scientist at heart. I love innovation. I love the next widget. I take every new iPhone update. Give it to me right away, pre-bug solving, right? I like to watch us invent, and I'd like to actually make a plug for Professor Dawson's new book on AI and academic integrity and how we should be thinking about teaching artificial intelligence and incorporating it into writing and things like that. So where I am, I have a number of students that are second language learners, right? They're now in law school, and I had a wonderful student who was translating the United States Constitution for her tribally enrolled grandmother and trying to find the words in their native language for what we call our Constitution, and this struggle of how to change some of these concepts. I think there are some fascinating things. Once upon a time, there was no thing called spell check. And we all had to know how to spell certain words. Now I just throw my fingers on the keyboard and it guesses and it knows where I'm headed. That has been a way to actually level the playing field, right? And so now when we think about persons that are second language learners, where some things are just so complex to translate in our space, could the AI help people who have had some kinds of barriers start to become a little bit equalized? I think there's a lot of promise of that in the tech community, in different places with different language and language abilities. My brain just doesn't know how to make a short sentence. I believe in run-on sentences. But I've heard from several editors that they don't care for them, right? Well, give me some help. And that has been the kind of ways at the individual level that we can start to see some change. What happens when college admission essays no longer just have someone who can afford $1,000 an hour coach to write your essay, but we've all got the AI to tell us how you're an asset to this university? Ooh, we're not ready for that. I'm on an admissions committee, so we're not ready for that. But these are the kind of things to come. I think at the individual level, I get very excited about a lot of things. But we serve a complex thing at this level, and you really struck me, right, that not only do we have a heightened duty, for when you sit for the bar, you'll have an ethical obligation to know how these things work. You are ethically required to know what the tech is doing to the people around you and the people that you serve. I take that as a very serious responsibility that you are going to want to embrace from now.
And on that question, of course, raises access to justice, and I wanted to just give a plug to the Legal Design Derby that is going on tomorrow. Jeff Ward, as you all know, is the director of the Duke Law and Technology Lab here, and the North Carolina Technology Law and Policy Center co-sponsor. And anyone here participating in the Legal Design Derby tomorrow? All right, there we go, yay. And so one of the wonderful things about the program is there is deep discussion about access to justice. I know that our students, as a result of the Legal Design Derby, about 3 years ago, Jeff, I want to say, before we were invited to be a co-sponsor, our students were really for the first time able to do a deep dive and to learn about the large percentage of individuals who need legal services that aren't able to get it. And there's a natural connection between what role is technology going to play in order to close that gap, but we also have to be mindful that we can't have a two-tiered system where you have the people who cannot afford attorneys just relying upon the inadequate AI, and folks that can afford a live human have the human plus the AI. So it will absolutely, I think, help on the individual level, especially when we're talking about access to justice and legal services, but we've got to be careful that we don't create this two-tiered system. All right, we have time for a few more questions. Okay, yes.
But no, I'll see before you came all the way over here.
So, as a broad concept, I am fearful of mass surveillance as the expansion of tech. That said, I'm curious how you all think about the alignment of algorithms with the truth and working in the space of ambiguity. So let's say you're trying to figure out recidivism rates potentially for someone, and you're trying to do it algorithmically, and your concern is that we're operating based on data that is filled with assumptions, filled with poor judgments of the past. If we were in a state where there's so much data about everyone, tracking everyone, where they go all the time, everything they say, does that lead to the elimination of the harms of discrimination if you have perfect knowledge of an individual, or does that still mean the propagation of discrimination?
Okay,
So this question reminds me of the debate about like how do we measure the accuracy of an algorithm, in particular the report by ProPublica that came out in like 2016, I think it was, right? Which, and for those of you that don't know, which I think basically everybody does, but they came out with this report that said, look, they're using an algorithm to determine, sentences in Florida, and it turns out that, the algorithm is getting it wrong in a really problematic way. It's getting it wrong in the sense that, it's predicting that these Black defendants are high risk, and then they're being released and they're not engaging in crime again. And it's predicting that these white defendants are low risk, but they are going out and immediately whatever, engaging in criminal behavior again. Right. So your question is sort of saying, well, like it's basically you're framing it to say like, well, maybe what they said is the right measure, right? Because the response from Compass, the tool to design that algorithm, was, well, that's the wrong measure. We use a different measure to determine what is accurate, and that measure, doesn't have to do with the outcomes. You're basically saying like maybe that is the measure, right? Maybe we should be measuring it based on what the actual outcomes are. Now, there's like tons of debates about, like the law in this context is totally agnostic. Like there's no right answer. The law does not tell us that like we should measure it this way or we should measure it that way. Computer scientists often say, I wish they would tell me which way to measure it because then I could do it, right? But underlying that question about what kind of measure we want to, take into consideration are all these political questions. So the way you framed your question made me think of, well, yeah, if we had perfect surveillance, you'd probably find out the same thing, because what's actually happening is that marginalized people who don't have resources, right, are going to continue going on without their resources, and people who are not being, who are not resource strapped have different life opportunities. They don't, travel. To say what you want about whether they engage in crime or not, they're not traveling in spaces that, the criminal law enforcement is, right? So there are all these questions, right, about how we get to the point of the outcomes we get to that are just political. And if we choose to live in the world of the sort of technical debate, we can obscure those bigger questions.
I also think that you already see that ambition already afoot in national security and intelligence realms. The idea that we need to have ubiquitous and comprehensive biometric and biographic profiling in order to stop the next terrorist attack, in order to try to fulfill pre-crime ambitions. And so that's already, I think, at play. But the question is that consistent with democracy? Is that consistent with our Constitution? So I think that it's a little bit dangerous to think in terms of the ends justify the means. Could we possibly never have any crime and never have any terrorist act again? At what cost? And if we are prepared to go in that direction of the ends justifying the means, then I think that that's extremely dangerous.
Professor Jones.
I have a question for Professor Hugh. You mentioned the AI Bill of Rights. You also mentioned the EU approach. And if I heard you correctly, and I may not have, it seems to me that the EU approach may be slightly ahead of what we're doing in the United States. Could you tell us, speculate as to why, and some of the differences in the two approaches and what you might recommend if we were thinking about a more ideal future for the United States?
Yeah, in the United States, for data protection, cybersecurity, as well as AI, we've taken a very sectoral approach that we segment off and we silo off which aspects of the industry or the field that we're going to regulate, and then we build legislation or regulation around just that aspect, whether it's health data or student information or financial, economic records. So in the United States, we just tended to steer away from an omnibus approach. And in the EU, they've gone very hard towards comprehensive structures. And so when they are suggesting that you can comprehensively regulate AI through the EU's AI Act, they're putting forth a framework that is not anything like in the United States that we're trying to put forward. Probably the closest is the AI Bill of Rights, but it's just a set of principles.
Well, I think we are about at time, but I'm going to turn it back over to Professor Jones.
Professor Martinez is going to close us out, but let me just say, Professor Dawson, I wish we had copies of your book here for signature because it sounds like incredible work. And it was just a pleasure to hear from you, Professor Gibson, because we've just met. And your description of how pernicious the black box is, right, in this moment, not really knowing what that box is doing. This is beyond junk in, junk out, right? This is something next level, so I really appreciate that. And then it's always amazing to learn as a teacher from your former students. Professor Eaglin, when you said disruption of hierarchy, I thought that sounds like one of my phrases. I very much appreciate that. But I'm also struggling with the issue that you raised that the undergrad, right, said he's going to spend a week researching. I wish he were still here so I could tell him to send over the results of his research because I think that's a really intriguing approach. And of course, Margaret, the problem, Professor Hugh, my apologies. The problem is not the technology with us. I think is something for all of us to think about. The reason I jumped up is because I don't know if you are aware, but the fall version of the Duke Law magazine focuses on AI and the effects on civil rights and civil liberties. So if you have not had an opportunity to read this, and if you want to learn more, this is at your disposal here. So let me turn this back over to Professor Martinez.
Yes. So, thank you. We thank each of our esteemed panelists this afternoon, for such an insightful conversation. I certainly was taking notes, and I know others were as well. I'll hand these over to you shortly, but please accept these as a small gift, in token of our these small gifts, that is, as a token of our appreciation. As well as to each of you, thank you for joining us today, even those who were online and remotely as this event was live streamed. We thank you for your participation. Please know that the Center on Law, Race, and Policy is organizing a symposium, a spring symposium on this topic, which will be a continuation of the conversation started here today. Please, to the extent that you are interested, or if you would like to be a part of that effort and the planning efforts, do not hesitate to contact us. And again, thank you for your participation. Have a great rest of your day.
Excellent.